Okay, give me one moment. Before I get started, are there any other issues or problems that I need to be made aware of or that we need to address?
No, Your Honor.
No, Your Honor, I'm good to go.
Okay. We have one more CAA form, trying to take advantage of my time, use my time wisely. Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by a jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bail. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God? Okay, let's begin on the ladies' side with Miss Cannon. Miss Cannon, good morning, ma'am.
Good morning to you too.
You're charged with one count of an open container violation. All of these are misdemeanor offenses that you're charged with. The bond for the open container violation is going to be set at $500. You're charged with one count of driving under the influence of alcohol. Bond's going to be set at $5,000. And you're charged with one count of tampering with evidence. Bond is going to be set at $1,000. So you're going to have a total bond of $6,500. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, yes, sir.
Okay, approximately how much do you make per hour, ma'am?
It varies. I work for a staffing company.
Okay,
So it varies from like 13, 15.
okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, I do not.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Harry?
Good morning.
Good morning, Miss Harry, ma'am. You're charged with one count of theft by taking as a misdemeanor. The bond is going to be set at $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, thank you, sir.
Okay. Do you have any questions of me, ma'am?
May you repeat so I'm sorry. If I bond out, I get a new court date?
Yes, ma'am.
Oh, okay.
So
All right, that's
just so
fine.
you understand, what happens is when you bond out, your case gets sent to the state court, and then it gets assigned a judge. And because I don't know who that judge is yet, we can't give you court dates for that judge. So once your case gets to that judge will then send notices out for that judge's court dates.
Okay.
Okay. All right, ma'am, you're free to go back.
All right, thank you.
You're welcome. Ms. Hughes. Ma'am, you're charged with two misdemeanor offenses. I've set the bond at $1,000 for each offense, so that's a total bond of $2,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, I've already done that.
I'm sorry, ma'am.
I've already filled out the paper. I was wondering if I can possibly get an OR bond. Someone just spoke to me.
Okay.
I really wish I
no.
won't walk with the wrong person. I just want to do a cut.
Okay, ma'am, I did not
Wasn't hanging
see
on
your form. So let me ask you this question again. Would you like for me to determine whether you qualify for the appointment of a lawyer?
Yes, you can.
Okay. Are you currently working, ma'am?
I don't have no income. I have income that I can't get because I don't have my birth certificate. So I can't get out on a $200 bond.
Are you currently working, ma'am?
No, I'm not.
Okay.
Trying to
You
get
do-
my stimulus from last April, my SSI checks. I have not yet got identity force. I'm not working.
Okay. You do
Trying
qualify
to get
for
all
the
these checks.
You do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. I'm going to deny your request for an OR bond. Is there anything else, ma'am?
No, there's not anything else. So I have to sit up in here and wait for April. Yeah, no income at this moment I can reach.
I would encourage you to speak to your lawyer and see what your lawyer can do. Your lawyer most likely can work something out with the solicitor's office for your release, but you're going to need to speak to your lawyer about that, okay?
I'm ready to go back home. I live in Virginia. I've been here
Okay.
almost 2 years. I'm so ready to go back home.
Okay. Is there anything else, ma'am?
I don't talk to me. No,
Okay. Okay, you're free to go
they
back.
talk a lot out here in Georgia. It bothers me. They talk a whole lot. So what is my court date or whatever? Because this man rushing me. I don't want to go to my cell, judge. I already said I was gonna say it to you because I have a female in there. I came in yesterday, of course. It's peeing on the floor.
Your Honor, is she?
And they want to make me go into some cell with the girl peeing all over the floor. This is nasty and waking me out my sleep.
Okay, ma'am, you're free to go back. Ms. Kilgore? Ms. Kilgore?
I'm sorry, Your Honor. There was a delay.
Since he's still in the court date, can you retire? Can you recite the court date?
Oh, excuse me, Your Honor.
April 26th at 8:30 in the morning, courtroom 201.
I'm sorry, Your Honor. You may continue.
Okay, are we ready to move forward with Ms. Kilgore?
Yes, Your Honor.
Ms. Kilgore, ma'am, you've been charged with one count of loitering or prowling. This is a misdemeanor offense. Bond is set by schedule at $1,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, did you say yes?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Miss Marion, you're welcome. You're free to go back, Miss Kilgore. It looks like the video is frozen.
You don't have to sell it, so it's waiting here. If you came from intake, waiting here, but you don't have to sell.
Okay, I can see it now.
Okay, Your Honor. Cool. Let me try it again. Give me one moment, Your Honor.
No problem. Okay, are you Miss Marion? Ma'am, you're charged with 2 driving-related offenses. The first charge is driving a vehicle with defective headlights. The bond is set by schedule, meaning it's automatically set at $500. You're also charged with one count of driving on a suspended license. This is also set by schedule. The bond is set by schedule at $1,500. So you have a total bond of $2,000. You're gonna have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. Excuse me, that date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, ma'am?
Yes.
Okay. Okay, ma'am, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, ma'am, you're free to go back. Miss McClure. Ms. McClure, ma'am, you're also charged with 2 driving related offenses. The first charge is driving on a suspended license. Bond is automatically set at $1,500. And you're also charged with having an obscured license plate. Bond is set at $500. These are both misdemeanor offenses. You're going to have a total bond set at $2,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. About how much do you make per hour, ma'am?
I make about 15, between 15 and 16 an hour.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, that'll be all. Thank you.
Okay, ma'am, you're free to go back.
Oh, I'm sorry. What was the date? You said April
April 26th.
26th. Okay.
Yes, ma'am. But that date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Okay, thank you.
You're welcome. Miss Neely.
Hey, how you doing?
I'm doing well, ma'am. You're charged with 1 count of aggravated assault. I've set the bond at $10,000. This is a felony offense. There's going to be a stay away provision on this bond to stay away from a Stacy Walcott. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201.
Hold on, can you repeat that one more time?
Yes, ma'am. April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
You didn't
sure.
fill out the form, so that's why I was asking. Do you plan on hiring your own lawyer? Or?
Yeah, my wife was gonna do it. So,
Okay. So now I can make that determination, or you can go with hiring your own lawyer. It doesn't make me. I'm sorry, ma'am.
I'll let you do it. Check into it for me just in case something goes wrong.
Okay. Are you currently working, ma'am?
No.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, not that I can think of right now.
Okay. You're free to go back, ma'am.
Thank you.
You're welcome. And I apologize if I pronounce the name wrong, but is it Pacheco? Good morning, ma'am. Did I pronounce your name correctly?
Good morning, you did, Your Honor.
Ma'am, you're charged with 1 count of contributing to the delinquency or deprivation of a minor. This is a felony offense. Bond is set at $3,000. You're also charged with 1 count of reckless conduct. The bond is also going to be set at $3,000. And I don't know if you are aware or not, but apparently these warrants were taken out in May of 2019. So that's where these charges are stemming from. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. About how much do you make per hour?
16.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back. Miss Shannon. Miss Shannon, ma'am, you're charged with one count of obstructing an officer. This is a misdemeanor offense. Bond is going to be set at $2,000. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, I'm sorry. How much do you make per hour, ma'am?
18.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Sorry, I just discovered an error that I made. Put the wrong information on the wrong form. Give me 1 second. Okay. Do you have any questions of me, ma'am?
No.
Okay. You are free to go back. Miss Smith, Bianca Smith. Ma'am, you're charged with one count of theft by taking as a felony. Bond is going to be set at $5,000. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
You say
Would you like
April
April 27th? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back. Miss Williamson.
Yes, Your Honor.
Ma'am, you're charged with one count of simple possession of a controlled substance. Bond is going to be set at $3,000. This is a felony offense, so your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201.
Sir,
That day,
I do have a question for you.
I'm going to get to that in a second. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was the question you wanted to ask?
I was actually called and turned myself in, or turned him in so I could get in a rehab center. What can you help me get in rehab?
Okay, so that matter is not before me at this time. Your case is going to get assigned to the public defender's office. Have you been in a rehab situation before?
No, sir.
Okay. Um, Speak to your lawyer, the district attorney's office. They will enter into, sometimes they call it they'll call it a drug court fast track. And basically what happens is your lawyer, district attorney's office, you work out a situation that will result in your being able to get treatment. And depending on what they negotiate, sometimes is treatment in lieu of punishment, so that there will be the possibility of punishment if you don't complete treatment, or they'll do certain things. They may consider other choices. But the short answer to your question is that yes, you can get help. You have to let your lawyer know so that your lawyer can advocate on your behalf with the district attorney's office. Okay.
All right, thank you.
You're welcome. You're free to go back, man. Miss Wilson.
What's the first name, Your Honor?
Danzel, her charges are set by schedule, so she could have bonded out.
That's a male,
Yes,
Your
ma'am.
Honor.
Yes, ma'am.
She's out the bond.
That's gonna be a male, Your Honor.
It's a male?
Yes, Your Honor.
Okay, I'm sorry. It does say that on this form. All right. So Marshall Pope or Pope
Your Honor.
Marshall. I'm sorry, go ahead.
Before she goes, we have a Sydney Reynolds.
Sydney Reynolds. Hold on. Let me look in my other stack.
Excuse me, Your Honor, when Ms. Marshall Pope goes up, can Mr. Bickham go up as well? He's featured on the male side.
Yes, sir.
I-
Okay. I do have Miss Reynolds. It's in the wrong stack. So let's see. Let's bring up Sydney Reynolds.
Good morning, Your Honor.
Good morning, ma'am. You're charged with 3 offenses. The first offense is driving a vehicle with defective equipment. Bond is going to be set at $500 for that. The next 2 charges are felony drug-related offenses, and bond is going to be set at $5,000 for each offense. So you're going to have a total bond set at $10,500. Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
Your
Would you
Honor,
like to?
I
Hold on,
apologize.
hold on 1 second, ma'am. Would you like me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. Okay, ma'am, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Now, what was your question?
I just wanted to know if you could repeat that date. I didn't get it. I'm sorry.
Sure, April 26th at 8:30 in the morning, courtroom 201. But keep in mind, upon your bonding out, that date will get waived and you'll receive a new court date in the mail. Okay?
Yes, sir. Thank
Any
you.
other questions, ma'am?
No, sir. I appreciate it.
Okay, ma'am, you're free to go back. So now let's bring up Miss Marshall and Mr. Rick Bickham. Okay. Miss Marshall and Mr. Bickham, you are both in the same position. meaning that you are alleged to be fugitives from justice. And what that simply means is that there is a warrant for your arrest in another state, and that other state has indicated to the Clayton County Sheriff's Department that they intend to extradite you, to bring you back to the requesting jurisdiction to have these charges resolved. In the case of Miss Marshall, you are charged with being a wanted person out of Greenville County Sheriff's Office in South Carolina. There's a warrant for your arrest for fraud. And Mr. Bickham, you're charged with being a warrant, I'm sorry, being a fugitive for justice. There's a warrant for your arrest out of Harnett County, North Carolina, for trafficking marijuana. So, for both of you, Clayton County has no interest in your innocence or guilt. We're simply holding you due to a contractual relationship that all states have, that they will hold a person that another state labels as a fugitive. This process involves two components. You can waive your right to a hearing today, and a clock will begin to run where each state, South Carolina, North Carolina, will have 30 days to come and pick you up and bring you back to that jurisdiction. They can request an extension of an additional 30 days for a total of 60 days. If either South Carolina or North Carolina, if they don't come and pick you up, you will get released out of the front door. But that does not mean the warrant goes away. So you could get released out of the front door. 5 minutes later, you encounter another law enforcement officer. They run your information. You can go right back to jail, and this process starts all over again. You have a right to have a hearing to determine whether you are the person named in the warrant and whether the warrant actually states a charge that can be prosecuted. If you were to tell me today that you want to demand that hearing, sometime between today and the next 90 days, that hearing will be held, where at that hearing, the only thing the judge is going to determine is whether you're the person named in the warrant and whether the warrant in fact states a charge. Are you with me so far, Ms. Marshall?
Sort of.
Okay. Do you have any questions? Because I'm here to answer any questions that you may have.
I still don't quite understand either one of these.
And so I'm asking you to tell me what you don't understand so I can explain it to you.
I would say if I waive my rights to a hearing, what happens?
If you waive your right to a hearing, the 30-day clock that I indicated earlier begins to run today.
Okay.
And if South Carolina does not come and pick you up within that 30-day period and they do not request a 30-day extension, you will be released from the sheriff's department.
Okay, so 30 days I gotta spend in jail.
Not necessarily. What I explain to people is this, especially during this pandemic times. A lot of times, person that's in your position or Mr. Bickham's position, if you were to hire a lawyer up in South Carolina, I've had, for example, people that appeared before me on a Wednesday based upon the same allegation, fugitive from justice. They either had a lawyer or hired a lawyer in the jurisdiction where they were located. They worked everything out, and by Friday, that person was released from the jail. So that's the importance of what you have to understand is that Clayton County is not here to do anything related to these allegations.
Okay.
So If we are told to release you, we will release you. If we're told to hold you, we will hold you pursuant to the statutory period of time. Okay? Any other questions, ma'am?
That's with waiving my rights, is that right?
What you're doing is you're waiving the hearing to determine whether you are the person named in the warrant and whether the warrant actually states a charge. That's what you're waiving. You're not waiving, you're not pleading guilty, you're not doing anything other than saying, hey, I believe I'm the person named in the warrant. I may not agree with the warrant, but I understand that it's charging me with a criminal offense. I'm innocent of that offense. I want to go back to South Carolina and I want to fight this. Okay. Whether you choose to have the hearing or whether you choose to waive the hearing, the end of that result of the end result will be you will be going back to South Carolina to deal with those charges. So the question is it going to be 6 months from now? Is it going to be 30 days from now? Is it going to be 10 days from now? You have control of that. That's the one thing you do have control over.
Okay, I'm just trying to figure out which one is the 10 or 30 and not the 90.
That is if you were to waive the hearing to determine whether you are the person named and whether the charge is in fact a charge. That's the only thing that you're waiving.
Okay.
Okay. So
I haven't had a lot of sleep.
no, ma'am. It's my job to answer your questions. So that's why we have this process. Are there any other questions that you have about this process?
No, but I would like to say that I was in the last 12 hours. They did not go ahead and do whatever they do to put you in jail. They did not let me call anybody. And I haven't eaten or had any food or anything to drink.
Okay.
The treatment was not good.
So what generally happens, ma'am, is there is you can imagine like this is a wieldy process. And sometimes your treatment is dependent upon when you enter the process. As the jail, primarily they're trying to get people before a judge as quickly as possible. And so depending on the time that you were brought into the jail, largely that dictates what they do. So what I do know, what they try to do is to get people before a judge as quickly as possible. And sometimes that may mean that you don't get a chance to use the phone as you may want to, or you don't get a chance to eat as you may want to. Generally, after this process, things slows down and you're able to use the phone, you're able to get medical attention, you're able to get the things that you need. So I apologize on behalf of the county for that, but it will happen. It will happen.
I stood in the window and watched. And when they got the point that they weren't busy, they didn't do anything. They literally didn't do anything. It was wrong.
I understand. And like I said, I do apologize on behalf of the county. But do you know what you want to do as it relates to waiving the hearing or having the hearing?
Yeah, we decided to waive the hearing.
Okay. They're going to present you with documentation. You're going to sign that. They're going to send it to me and I'm going to sign. And the process will begin to run today. I can't state anything of certainty, but based upon what I see, if you're able to get someone to contact the authorities in South Carolina, you have a very high likelihood of walking out of this jail and having to go back and deal with those charges on your own. Okay.
Yeah, well, I can somebody if I can get to the phone.
Okay. You will be allowed to use the phone after this hearing. Okay. Mr. Bickham, is there anything else, ma'am?
No.
Okay. Mr. Bickham, did you hear my conversation with Ms. Marshall?
Yes, sir, I did.
Do you have any questions about this process?
No, I fully understand the process, but I do have questions about like the way the process was handled overall.
Okay.
So, I just heard you tell, the other lady that, Clayton County is not interested in my innocence or guilt or my prosecution in this case at all.
That's
So
correct.
I was apprehended at the airport by the, fugitive task force and I guess the marshals for the warrant. I guess you guys have this connection between states. And, but I had money and I had money on me, not a large sum of money, just pocket money. And I had jewelry on and they confiscated everything here, not by request of, North Carolina, because I'm on bail from North Carolina with a paid attorney. I'm not exactly sure why they revoked it. But like, this has nothing to do with Clayton County. And, the money just spending money. I have no money on my books. I have no one in this state. I'm just passing through. The jury was left to me from my family. I got receipts and GI certifications at home, and I just don't want to get caught up in the process of everything that's going on because I may never see this county again during with COVID and everything going on. I just really don't understand like what that would benefit them for keeping it here if I don't have any charges here whatsoever.
You're saying your property?
Yeah, like, well, they gave me the clothes I was wearing, but it's like I had, my carry-on suitcase. They're like, oh, the jail's not going to take this. We're going to put it in evidence. I had my money. They're like, oh, you don't want to answer our questions after we Mirandatize you, but I just exercised my right to remain silent. I don't have anything to do with this county. So once I exercised my right to remain silent, that's when everything kicked into place. They confiscated my jewelry, went from my property bag to an evidence bag that's going to go in an evidence locker somewhere. My money went from a property bag to an evidence bag that's going to go in evidence somewhere. It's like $900. You know what I mean? And it's just like, I don't know. They deal with a lot of different walks of life. So maybe they thought I was being a jerk or maybe they're trying to be spiteful, but I just would like to get my stuff and go about my business and take care of my situation so I can get back to my family without having to revert back here. Because, it is worth a large sum of money.
Oh, okay. I was listening to you. I have an answer for you.
I'm ready. Apologize for
Okay.
the long drawn out,
No. I understand. So what happens is this. If your property is placed in an evidence bag, the agency that made the arrest, they will place that property in evidence. You still have an ownership interest in that property that's placed in evidence. If there is some kind of connection between that property and any crime that's being investigated, that property may remain in evidence. As it relates to things like cash, most often what happens is that cash gets logged into evidence, and unless the cash itself is considered contraband, meaning let's say like they believe it to be fraudulent, that is forged documents. So that may be evidence that is brought out in a trial. It remains in evidence. If it is cash, they will convert it into a check. And so you can understand the value of just not having cash sitting around on a shelf where someone can just come and open the bag and take some money out. So that relates to the cash. As it relates to a suitcase or anything like that, placing it in evidence is actually for your benefit because it gets basically is safely kept. You will have the ability to request your property back, your money back, everything back. If you are in a situation where let's say you're arrested at the airport and they just leave your suitcase there, somebody could walk along and take your suitcase and now they're enjoying your items.
No,
So hold on, place it in an evidence is safekeeping for your benefit. The sheriff's department is not in a position where they're going to take your suitcase because that's not evidence. Any property that is on you when you're booked in, the sheriff's department will place it in their own storage so that when you bond out or you leave, you get everything that they took from you here. So it looks like it was the Clayton County Police Department that arrested you. So you're going to have to go through the Clayton County Police Department to obtain your property back. And it's simply a request for the return of property.
I mean, I understand about the suitcase, but it's like you said about the cash and the jewelry. There's no evidence. I mean, it's not, there's nothing that they need to keep here to, to help my case, not to help it, but that's evidence a part of the case I have going on there. What I have going on there has nothing to do with here. They don't want my jewelry there. They don't want my money. Like, they already returned that to me when I got bailed out from there. It was just, what I mean? It's literally, Your Honor, that I can understand the suitcase, but the suitcase is not here. It's at their police station, wherever they're at.
I understand. Let me try to explain it to you, Mr. Bickham. I don't know the jewelry that you had. Let's say it's $100,000 worth of jewelry, and you're walking through that jail with $100,000 worth of jewelry. You're probably going to be stuffed in a locker somewhere with blood coming out of you, and somebody's going to be walking around with that $100,000 jewelry. So do you understand how that?
I do understand. I think that I'm kind of not being too clear. I wasn't trying to keep it on. I just wanted it to be put in my property with the rest of my property here in the jail, where they store the property in the jail. My property is not in this jail. It's not, the sheriff's department doesn't have it here. They have it at Jonesburg or wherever the narcotics.
If you were arrested by the Clayton County Police Department. So let me, again, I don't know your case. I don't know if they're looking at you as being El Chapo Jr. And they are investigating you in that regard. So I hear what you're saying. I'm explaining to you the circumstances under how and where that took place. You definitely need to speak to your lawyer about it, because again, sir, you could be El Chapo Jr. They could have had helicopters watching you the whole time. I don't know. And so when you're telling me about this, I have no idea. All I can tell you is that there's a process that's in place. There's a process that your lawyer would know and how to obtain that property. It's not going to be the officer that arrested you. I guarantee you, he's not walking around now with your jewelry on. I guarantee that. So, sir, you know your circumstances, and I'm not going to ask you about your circumstances. I can only explain to you the possibilities under where what you've explained to me, how that can happen.
Yeah. And I understand that. That's what I'm saying. It went from my property bag to them saying, oh, no, we're not giving it to them. We're going to take it.
Sir, again, I don't know if you are Mr. Smith that teaches Sunday school every Sunday, or if you're El Chapo Jr. I don't know. So I can't answer what you were trying to get me to answer.
Yeah. I mean, but even the state has interest in El Chapo,
Sir, let me ask you this. Do you know where I went to school? Do you know what I did yesterday? Do you know what I said to my wife this morning? You don't know any of that stuff because you're not involved in my life.
No, yeah, for sure.
So if I come to you and I say, well, you know what? I talked to my wife and she said, blah, blah, blah. And like, I don't know your wife. I don't know this. Maybe you messed up. Maybe you didn't mess up. Maybe she's right. Maybe she's wrong. I am a stranger to you, just like you are a stranger to me. If law enforcement took it, they took it for a reason. But it's in evidence, and that you have a lawyer, and you can make the appropriate steps to take it back. Because I don't know you and I don't know the circumstances of your case, I am not going to opine as to whether it was appropriate or inappropriate, whatever took place. That matters not before me. The question before me right now is, do you want to sign the waiver or do you want to have the hearing?
I signed the waiver.
Okay. Did I answer your questions to your satisfaction, Mr. Picker?
Yeah, you did. I just have one more question. What's the process that I take to start to like get my stuff back?
If this was taken for safekeeping, then you most likely would just have to call over to the Clayton County Police Department to request the return of your evidence. I mean, your property. If it was taken as a part of a larger investigation, you will most likely have to go before a judge to have a judge sign an order for the return of that property to you. Because upon request, if the police say, well, we're investigating Mr. Bickham for X, Y, and Z, they will have to show to a judge's satisfaction that the property that they're holding is properly subject to an investigation. And if they can't, the judge will sign the order for the return of the property. Okay?
I can make that request while I'm still in custody, or do I have to be out of custody to make the request for the property?
The best thing for you to do is to first get yourself out of custody and then go back and get this, because you said you have a lawyer. First thing you should be worried about is your freedom, not some jewelry. Once you have your freedom, then you can start worrying about the jewelry and the money. Because you get it back and you're still in custody, it's not gonna come to you. Okay?
Oh, for sure.
Anything else, sir?
No.
Okay, you're free to go back after you sign the waiver. Let's switch over to the male side.
Oh,
Let's begin with, and I apologize if I mispronounced the last name, but it looks like it says a Mason or a Manson, M-A, I'm sorry, A-M-A-S-O-N.
Yes, supposed to be spelled A-M-O. Sorry,
Sorry, sir.
it's supposed to be spelled A-M-O.
Ah, okay. Sir, I'm gonna make that change on your bond form, just so it will hopefully prevent any confusion. So you're charged with 2 driving related offenses. The first is driving on a suspended license. The bond is going to be set by schedule, which means automatically set at $1,500. You're also charged with having a expired tag. The bond is set at $500 for that offense. Your total bond is going to be $2,000. These are both misdemeanor offenses. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to, well, it looks like you said you refused. You're going to hire your own lawyer, sir?
I'm homeless. I can use a lawyer.
So you want me to see if you qualify?
Yes,
You said you're homeless. Are you currently working?
I know.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I know, sir.
Okay, you're free to go back.
You said April 26th.
Yes, sir, but that date will get waived upon your bonding out. And based upon these charges, if you don't believe that you're able to bond out, speak with your lawyers and they can move this process along a lot faster.
Okay, thank you, sir.
Okay, you're free to go back. Mr. Anderson. Mr. Anderson, sir, you're charged with 1 count of battery. Your bond's gonna be set at
That's not me. Are you looking for Michael Anderson or James Anderson?
James Anderson. I'm sorry, James Anderson. Mr. Anderson, sir, you are James Anderson, correct?
Yes, sir.
Sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. And you're charged with 1 count of false imprisonment, which is a felony. Bond is going to be set at $10,000. So you're going to have a total bond set at $15,000. There's going to be a stay away provision on this bond, stay away from a Cynthia Anderson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Anderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
She's not able to bail me out at this point.
No, you can go through a bonding company, but Cynthia Anderson is not going to be allowed to be on your bond.
Thank you.
Okay, you're free to go back, sir. Michael Anderson. Okay, Mr. Anderson, you're charged with 2 misdemeanor offenses: possession of marijuana less than an ounce. Bond is going to be set at $1,500. And use or possession of drug-related objects. Bond is also going to be set at $1,500. So that's a total bond of $3,000. You're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Anderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Yes, sir.
Mr. Is it Bath, B-A-T-T-H?
Yes. Leave the blanket if you didn't bring it. Huh? Leave the blanket. Yes, sir.
Sir, you're charged with 1 count of simple assault. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Crystal Conklin. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer, sir?
Yes.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, sir, you're free to go back. Mr. Battle. Mr. Battle, sir, you're charged with 1 count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. 1 count of possession of a weapon by a person or handgun by a person under the age of 18. Bond is going to be set at $5,000. That's a misdemeanor. And you're charged with possession with intent to distribute marijuana. Bond is also going to be set at $5,000. So hold on, sir. I'll let you speak. Just let me speak. So you're gonna have a total bond set at $15,000. Your preliminary hearing date is gonna be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I cut you off. What is it that you wanted to tell me?
Oh, now I was just gonna ask you, what is $15,000? And I was gonna ask you, do that first offender jump, is that not real, or like what that is? I ain't never been in jail.
Okay. So we're not at that stage yet, but first offender is real. That's something that you should have a discussion with your lawyer about based upon the facts and what take place. Your lawyer may look at the case and say, hey, I can get these charges dismissed. So you're not looking at first offender. Or the lawyer may say, hey, look, they got you. So now that comes into play. But that's a discussion that you have with your lawyer. Okay, sir?
Mm-hmm.
Any other questions?
No, sir.
Okay, sir, you're free to go back.
All right.
Mr. Bullock.
Your Honor, he was the one had the drug.
Oh, yes, sir. Thank you. So I'll do a continuance order for Mr. Bullock for tomorrow.
Yes, Your Honor.
Mr. Chung.
Chung, bro. Chung.
C-H-U-N-G.
Yes, sir.
Sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Sabrina Chung. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That day will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, sir?
Yes.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Trump?
No, sir.
Okay, sir, you're free to go back.
What was the bond amount again?
I'm sorry, $3,000.
Thank you.
You're welcome. And I guess it's is it Emile, Emelle?
Yes, sir.
Sir, you're charged with one count of failing to register. Bond's going to be denied at this point on this offense. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to appoint you a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
All right, thank you.
You're welcome. Mr. Ford.
Yes, sir.
Mr. Ford, sir, you're charged with one count of felony theft by receiving stolen property. Bond is going to be set at $10,000. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Ford?
No, sir.
Okay, sir, you're free to go back. Mr. Gay, Gaye.
How are you doing, Your Honor?
I'm doing well. Sir, you're charged with one count of battery. I've set the bond at $10,000 for this offense. It's listed as a misdemeanor, but you have a lot of arrests for this behavior.
No.
I'm sorry, let me finish. You're also charged with criminal trespass, damage to property. Bond is going to be set at $3,000. And you're also charged with criminal trespass. Bond is going to be set at $3,000. So you're going to have a total, hold on, sir, please. You're going to have a total bond set at $16,000. There's going to be a stay away provision on this bond to stay away from a sincere Shannon. Do you understand that?
I do.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
I do.
Okay. You do qualify, sir. You're going to, I'm going to appoint a lawyer to represent you. Now, before I let you ask the question, I may be able to answer the question you're asking. The reason I set the bond at the amount that I set it is because on two separate occasions, warrants have been taken out for your arrest for an allegation of domestic violence involving Miss Shannon. There is a warrant taken out on December 30th of 2021, and there's warrants taken out on March 17th of 2022. Both involve Miss Shannon as the victim. So that's why I set the bond the way that I set it. So did I answer the question you were going to ask, or do you have a different question?
No, you did not answer my question.
Okay, what's your question?
It was pertaining to that, but you said that I was arrested multiple times for battery.
Okay, so I misspoke, sir. You had two warrants pending at the same time involving allegations of domestic violence, where both you and Miss Shannon. I just gave you the date, sir. I mean, you want me to give you the warrant numbers too, so you can verify it?
No, the only problem I have with it is I was not aware, and actually I am the person that everything was happening to. The only thing is I left. I just left. Every time I was never the aggressor or the person that started anything. So the fact that I'm the one that has to pay and have this slander on my name that's the problem that I have. And I'm not the person that looks like. I'm the one.
Okay, okay,
person that
okay. So let me give you a piece of advice. It sounds like you're saying that your relationship with Miss Shannon is toxic and that she is the person that is offering violence against you. Is that correct?
Precisely.
So should you stay around her or should you leave her alone?
It's been many times that I've tried to leave.
Should you stay around her or should you leave her alone? She's not like, she can't command you to be around her. You
But
can choose to, sir, you can choose to leave. If you choose to stay, you now have 2 warrants for your arrest that she is the complaining witness. Sir, I'm not saying you're guilty. I'm not saying you're innocent. That's why we appoint lawyers to represent you. All I'm telling you is that what I see from now, if you choose to go back around Miss Shannon, there's going to be another warrant for your arrest at some point in the future. So that's your choice. If you want to live your life like that, that is your choice. Okay? So I'm sorry, I cut you off. Any other question?
I lost my train of thought.
I'll tell you what, sir. I'll let deputies, would you let Mr. Gay just have a seat and we'll come back to him at the end. I'm going to allow him to gather his train of thought because it's unfair for me to not answer a question. Do you understand that, sir? Okay, we'll have a seat. Well, let's bring up Mr. Harris, Derek Harris. Mr. Harris, sir, you're charged with 1 count of theft by taking. That's a misdemeanor. Bond is going to be set at $2,000. You're also charged with 1 count of simple possession of a controlled substance. Bond is going to be set at $3,000. You're charged with 1 count of use or possession of drug-related objects. Bond is going to set at $1,500. Charged with giving a false name, address, or date of birth to law enforcement. Bond is going to be set at $2,000. And you're charged with criminal trespass. Bond is going to be set, at $3,000. Now, the simple possession is a felony offense. So your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me, Mr. Harris?
Not really.
Okay, sir, you're free to go back. Is Herschel Harris, is he OTB?
Yes, Your Honor.
Thank you. After Mr. Herschel Harris, we have Mr., is it Hedden or Heaton, Headen?
It's Heaton.
Heaton. Sir, you're charged with 1 count of theft by receiving stolen property, being a firearm. Bond is going to be set at $10,000 for that offense. 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. 1 count of 1 count of driving on a suspended, 1 count of driving a vehicle without a valid license. Bond is going to be set at $1,000. And 1 count of driving a vehicle without valid insurance. Bond is going to be set at $1,000. So that's a total bond of $13,500. You're going to be, you're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back. Mr. Howell.
Hey there, how are you?
I'm doing well, Mr. Howell. Sir, you're charged with 1 count of driving a vehicle with no tail lights. Bond is set by schedule, which means automatically set at $500. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're charged with 1 count of possession of more than an ounce of marijuana. Bond is going to be set at $5,000. You're charged with 1 count of, and that's a felony offense. You're charged with 1 count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. That's a felony offense also. You have an open container violation. Bond is going to be set at $500. And finally, you're charged with possession with intent to distribute the marijuana. Going to set the bond at $10,000. So you're going to have a total bond set at, let's see, $22,500. Your preliminary hearing date is going to be set for April 27th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer, Mr. Howell?
Yes, sir. And could you repeat that date for me real quick?
Yes, sir. April 27th at 8:30 in the morning, courtroom 201. I'm going to find that you qualify for the appointment of a lawyer. Do you have any other questions of me, sir?
Yes, sir. So would I be able to bond out like ASAP as soon as I'm released to a bond, or not as of right now? I was asking for, I work also, and I was asking because if I needed to do like, or could do work release just in time in that, because I do have 2 kids also.
Okay. So the answer to your first question is that you will be able to bond out today once the jail receives the paperwork. After this hearing is over, I have to prepare the paperwork and send everything back to the jail. And they start inputting the information into the system. Once that process is complete, you will be able to post a bond. So you know the bond amounts that you've been given. When you go back and you're able to use the phone, you can start calling people and start making arrangements, okay?
Yes, sir. And could you send me that amount one more time? Was it 22,000? How much?
22,500.
All right, thank you.
You're welcome. Mr. Arthur Jones.
Morning, y'all.
Good morning. Well, it's now afternoon. Mr. Jones, sir, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. This is a misdemeanor offense. There's going to be a stay away provision on this bond to stay away from a Kelly Jones. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Jones?
Yes, because I do work and I guess what I need to know is if I could bond out today. If I can bond out today, we both share a home and a son and whatnot, and my stuff is there. How would I go about getting my stuff? Because I can't lose my job.
I understand. When you bond out, sir, as you're going through the process, make arrangements with the sheriff's department so that there will be an appointment time that you show up with the sheriff's department, with a law enforcement officer, maybe the police, but someone is going to be there so that you can obtain your items so that you can continue with your daily living, and then you'll be able to get your stuff and leave. It's not going to be a move-in situation. So law enforcement not going to be there for 5 or 6 hours while you're, moving everything out. But it's just because this most likely will be a temporary situation. There's an understanding that there needs to be a temporary sort of bridge until this matter is resolved.
Okay.
Any other questions, sir?
No, okay, no, that should be all. Thank you.
Okay, you're free to go back, sir. Mr. Long,
Afternoon, Your Honor.
good afternoon, sir. You've been charged with 4 felony offenses. Possession of marijuana over an ounce, possession of marijuana with the intent to distribute, possession of a firearm during the commission of a crime, and possession of a firearm by a convicted felon. I've denied bond on these 4 offenses at this time. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning, courtroom 201. I'm going to also set a bond hearing date for April 29th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
And I will let you speak. I promise I will let you speak. Okay. I'm going to find that you qualify for the appointment of a lawyer, sir. I am going to appoint a lawyer to represent you. Now, what is it that you wanted to tell me?
I needed to try to hold my job, sir. I would like to bond out if possible. I have a job, so I work 6 days a week, sir. I just bought a house in September. I face losing my house if I can't bond out to continue working to pay my mortgage, sir.
Okay. I'm going to deny that request at this point, Mr. Long. You have to understand, sir, the allegations are that these items were found during a traffic stop. So I have to assume that these items were under your custody. You have a co-defendant, Mr. Michael Anderson, who was also arrested at the time. So
yes, sir. Everything that I had, Your Honor, I took responsibility for. That would be amount of CBD marijuana in my fire. I'm sorry. Everything that I, yes, sir.
So hold on, sir. The thing that I'm trying to impart upon you is that the decisions that you made are the decisions that you made.
Understandable. But what I was saying was, sir, some of the decisions that I made were the charges weren't true. The convicted felon isn't true. The other stuff isn't true.
Hold on 1 second.
Yes, sir.
I'm gonna look up your criminal history.
Yes, sir. I was granted first offender and I still got a convicted felony on my.
When were you granted first offender?
2006, 2004, I want to say 2005 from Butts County, sir.
Did you successfully complete the first offender?
Yes, sir. Yes, sir. No violations, no parole, no anything. No, sir.
Did they discharge you from the first offender?
Yes, sir. Yes, sir. And all my rights were restored back. Could I maybe sit here and talk to you later, let you look into it? Because I really would like to get a bond and I really don't think.
Okay, you have a seat with Mr. Gay so I can at least finish these individuals.
Yes, sir.
It won't take long for me to look at your criminal history. Mr. McFadden.
Good afternoon.
Sir, good afternoon, sir. Do you understand what you're charged with?
Yes, sir.
I cannot set bond at this hearing for these charges. I'm going to set a preliminary hearing date for April 25th at 8:30 in the morning. Because of the nature of these charges, you're going to have to appear before a Superior Court judge for a bond hearing. I don't have that date yet. It appears that you're going to hire your own lawyer.
Yeah.
Okay.
But do I qualify for one just in case? I might can just,
You didn't fill out the form, so do you want me to qualify you?
Yes, sir.
Are you currently working?
Yes, sir.
How much do you make per hour?
I make $20 an hour.
Okay, you do qualify, sir. I am going to appoint a lawyer to represent you. I'm sorry, give me 1 second. Um, So whether you retain a lawyer or whether you go forward with the appointed lawyer, there's going to have to be a bond hearing date set for you. Do you understand that?
Yes, sir.
Do you have any questions for me, Mr. McFadden?
No, sir.
Okay, you're free to go back.
Thank
you. Mr. Mitchell. Mr. Mitchell, sir, you're charged with 1 count of simple battery. Bond is going to be set at $3,000. You're also charged with 1 count of criminal trespass. Bond is going to be set at $3,000. That's a total bond of $6,000. You're going to have a stay away provision on this bond to stay away from a Krishana Ivy. Do you understand that, sir? Give me 1 second. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Mitchell. Mr. Reese?
Yes, sir.
Mr. Reese, sir, you're charged with 1 count of driving under the influence of alcohol to the extent that it made you a less safe driver. Bond's going to be set at $5,000. This is a misdemeanor offense, so you're going to have a preliminary hearing date set for April 26th at 8:30 in the morning, courtroom 201. That day will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. It said you refused. Are you currently working, sir?
Yes,
But how much do you make per hour?
17.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I would like to pay cash bond tomorrow at a lower cost because I get paid tomorrow. I work for FedEx, and Saturday will be my day to start back work.
Okay. Currently, you have 3 options in posting bond: cash, commercial, or property. Cash means you pay the entire amount in cash. The sheriff's department will hold that money and then return it to you when your case is over. You can go through a bonding company where you pay a percentage of the bond, generally about 10%, 10 to 12% of the bond. That amount that you pay is a fee for the bonding company. They will not return that money. If you have property in Clayton County, you can use that property as collateral. The property, I mean real property, real estate. Property has to have at least an equity of at least 3 times the bond amount. So in your situation, the property will at least have to have an equity of about $20,000, $25,000. Sheriff's Department places a lien on that property. When your case is over, they remove the lien. Those are the ways that you can post bond.
Right now, me and my wife, we getting ready to buy a house. And all the money that went in the land in that house, I get paid tomorrow, and I have my bank card in my pocket that I can pay straight out, but I don't.
This is, yes. What it sounds like you're negotiating the bond amount. I set, as maybe you've heard, I've set every bond for this offense at the same amount for everyone.
Well, this is the first time I ever called a charge like this. I've never been DUI and none of that.
I understand. I understand, sir.
Can you give me a signature bond?
No, sir.
I just can't afford it right now. And not with the bond that you put down, I can't afford it.
It's hurting me because my job on the line and everything.
And I do understand that. It looks like it says that you were arrested at 12:30 this morning.
Yes, sir. Just got off work at something like 10, from 6 that morning to 10 that night, on the way home. This is a livelihood that I didn't fought for, to have a house and land and everything, and I made one mistake.
All right, Mr. Reese, you have successfully argued your case. I'm going to dismiss this charge.
Thank you.
So what's going to happen is when I'm done with this, when I'm done with this hearing, I prepare the paperwork. I send everything back to the sheriff's department and they will enter into the computer. And when they enter into the computer, you will be released, but that's going to take at least a couple hours.
I can deal with that.
Okay. And sir?
This is my punishment for what? The mistake that I made.
I looked at your thing again and I'm comfortable with dismissing this charge. Okay. All right. You're free to go back.
All right, thank you.
You're welcome. Mr. Sawyer. Mr. Sawyer, sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. This is a misdemeanor offense. So your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. There's going to be a stay away provision on this bond, stay away from a Rebecca, looks like either Maines, Maines. Do you understand that, sir? Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir, you're free to go back. Mr. Marquise Smith. So you're charged with 1 count of theft by taking as a felony offense. I've set the bond at $5,000. You're going to have a preliminary hearing date set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you're on the borderline, but I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you for that.
Okay, you're free to go back. Mr. Tomlin. Mr. Tomlin, sir, you're charged with 1 count of simple battery. This is a misdemeanor offense. Bond is going to be set at $5,000. You're charged with. I'm sorry, did you say anything?
No, Your Honor.
Okay, you're charged with 1 count of theft by taking. Bond is going to be set at $5,000 for that offense. And you charged with 1 count of aggravated assault. Bond is going to be set at $15,000. So you're going to have a total bond set at $25,000. There's going to be a stay away provision on this bond to stay away from a Celeste Thomas. Do you understand that?
Yes, Your Honor.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, your preliminary hearing date is going to be set for April 27th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. I do find that you qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, Your Honor.
Yes, sir.
I really want to take trial for the you said theft by taking?
Yes, sir. That's one of the charges.
Yes, sir. I want to take a trial. I want to take that to trial because everything they accused me of stealing was in the house and never left the house.
So, Mr. Tomlin, at this stage, we're not determining guilt or innocence. Once you bond out, your case is going to get moved to the Superior Court. I've appointed a lawyer to represent you. That's where you have the discussion about going to trial.
Okay.
Okay. Anything else, sir?
Am I approved for any type of bond?
Okay. What did I say your total bond amount?
Okay,
is?
25.
That's your bond.
Okay.
Anything else, sir?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome. Mr. Weaver.
Yes, sir.
Mr. Weaver, sir, you're charged with one count of hit and run, accident, basically leaving the scene of an accident.
Yes,
The
sir.
bond has been automatically set at $1,500. This is a misdemeanor offense.
Yes,
Your
sir.
preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, Mr. Weaver. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Is there any way that I can bond out today?
Yes, sir.
Okay.
So when it'll take probably a couple of hours, but you should be able to use the phone after this proceeding, and you can contact either a loved one or a bonding company. You know what your bond is set. You actually can do that now because it's already been placed in the system. So you should be able to make arrangements to bond out immediately.
Okay.
All right. Anything else, sir?
So the bond has already been in progress?
It has been, this is an offense. Some offenses, the jail has what they call a schedule. So they will automatically just assign it to you. So you didn't even have to come before me. You can go make your arrangements and you can bond out now.
Okay.
All right, sir. Free to go back. Mr. Marquise Williams.
Yes, sir.
Okay, sir, you're charged with one count of criminal trespass. That's a misdemeanor offense. Bond is going to be set at $3,000. You're also charged with one count of battery. Bond is going to be set at $5,000. So you have a total bond set at $8,000. There's going to be a stay away provision on this bond to stay away from Jamelia Abdul Hakim. Do you understand that, sir?
Yes, sir. One question.
I'll get to that in a second. I'll get to that. Your preliminary hearing date is going to be set for April 26th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Now, what was your question?
The officer, it was simple battery.
Yes, sir.
Is it simple or is it battery?
It's listed as simple battery on the bond from the allegations.
Yes, sir.
You know what? I'm going to change that the bond for the simple battery to $3,000. So you're going to have a total bond set at $6,000.
Yes, sir.
Okay, sir?
Yes, sir. Thank you.
You're welcome. Any other questions?
No, sir. You have a blessed day, sir.
You too. All right, let's deal with Mr. Wilson. Mr. Wilson, sir, you're charged with 3 driving related offenses. These bonds have been automatically set, which means they're set by schedule. So you're charged with 1 count of improper lane change. The bond is set at $500. One count, driving a vehicle without insurance, bond is set at $1,000. And one count of driving on a suspended license, bond set at $1,500. So you're gonna have a total bond set at $3,000. You didn't fill out the form. Does that mean you plan on hiring your own lawyer?
Oh, no, I mean, I thought the form was actually for a lawyer.
Yes. So you didn't fill it out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Wilson?
Yes, sir.
About how much do you make per hour?
$17.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. So at the time I got these charges, I was trying to explain to the officer that my license was reinstated and I did pay the ticket off. And he did, I guess he said that that's something that you take up with the DMV, but I was at work at the time. So I had to basically just leave work to they incarcerated me. And he didn't give me a chance to even look in the glove compartment to show him that I had insurance. So I was working, I had the insurance, I've actually paid the ticket off. The DMV is something once I leave jail, that I'm going to have to give the documents that they gave me to show that I reinstated my license. I got my State Farm binder at home that I can prove if you give me a chance to come back before you, I can bring that back as well to show you that I had insurance on my car. All this time I've been sitting here, my job is, I had to work today. They don't even know where I'm at, so it's no call, no show today. I'm trying to get out of here, but I wasn't able to get no phone calls to on my phone to make any phone calls to anyone. Is there any type of way that you would help me with like a signature bond or anything that I could just present the documents before court and show that all these charges that's been against me are not legal? I mean, are not what's supposed to be against me right now. Only charge was the improper lane change. If he wants to charge me with that.
Okay. Okay, Mr. Wilson, this is what I'm going to do. I'm going to change these bond amounts to $500 each. You're gonna have to get that information. And let me see. You did say you wanted me to appoint a lawyer. Okay, get this information, give it to your lawyer, and if what you say is true,
yes, sir.
These charges will most likely be dismissed.
Okay. And I do have documents to back up what I'm saying as well.
That's fine. You will not come back before me.
Okay.
Okay, you're gonna have to, this will get transferred to either the traffic court or the state court.
Okay.
And your lawyer will have the opportunity to speak to a prosecutor, okay? All right, you're free to go back, sir.
Okay, could you tell me my the bond amount or what I need to do next?
It's $500 each, so that's a total bond of $1,500.
Okay, thank you, sir.
You're welcome. Let's bring Mr. Long back up.
Yes, sir, Your Honor.
Mr. Long, I've looked at your criminal history and I'm not going to change my decision.
Yes, sir. Could I ask why, if you don't mind?
You have 9 cycles, which means you have 9 interactions with law enforcement.
Most misdemeanors? Only felonies were first offenders in 06?
Looks like you're charged with possession of methamphetamine, October 27th of 2013.
That was given a first offender too, sir, in DeKalb County.
Mr. Long, I'm not changing my mind. You're not being persuasive.
Yes, sir.
We can sit here and have a 3-hour conversation about something I'm not going to change my mind about.
All right, I'm off of it. Is there anything I can do to try to appeal that, and I'll be gone?
To appeal what?
Maybe to get a bond. Is there any way I can get a bond to keep my job in my house, sir? I just bought a house. I got a mortgage.
Mr. Long.
Yes, sir.
You've been around. You've
understand.
been around. You have been around.
Yes, sir. And understand, I'm a changed person. That was when I was younger. I'm now 40. I grew up out of those ways. I promise, sir.
I understand. I'm not gonna change my mind.
Fine. You have a
You-
great.
You're welcome. Mr. Gay. Were you able to remember what you wanted to speak to me about, sir?
Um, I just wanted to make it known that, I kind of forgot again. Basically what I was trying to let you know was, what I'm trying to make is all those situations that happened, even though you said there were two, situations. One of those situations, both of those are together. And I just want you to know, I was never the aggressor. I'm always the guy that's trying to make things right. And basically a question I would have was, what should I have done in that situation? Because I don't see anything I could have done. I've tried to leave. I've been restrained. I've had her put her body against the door to where I cannot leave. I've had her drag my clothes, rip my clothes up. I've had so many things. It's been
How often has that happened?
It's happened, honestly speaking, it's happened maybe at least once a month. That's honestly speaking.
Why do you go back?
Because I actually am a good person. I am a good person. That's literally all I can say about that.
And what has that gotten you? How has that benefited you?
I was never in a relationship for benefits, to be honest. I've been trying to help her.
What I mean, Mr. Gay, is that you're sitting in jail right now saying that the person that has been beating on you once a month, you go back to because you're a good person. At some point, you have to start thinking about self-preservation. And until you start thinking about self-preservation, you're going to be in jail. You're going to be coming back to jail. We might as well start setting appointments up every month for you to come back and you to tell me how she beat you behind this last month and how you left and you tried to be a good person. You tried to leave, but you didn't leave. So she went to the police and she got you arrested, and you're just such a great person. And you don't know how you can stop yourself from going back to a person who you say is abusing you and having you arrested. I'm not your father. I cannot lead your life. You have to lead your own life. And this is what you want out of life. This is what you're going to get. Do we understand ourselves, sir?
Sir, can I get 1 second?
Yeah.
As speaking about my father he was in law enforcement. So my mother, she died when I was at least 1 year old.
I'm sorry to hear that.
So when it comes to women, I've seen my father sacrifice himself. So it's like, I understand her because I know where she comes. She comes from,
When you say you understand her, are you saying Miss Shannon?
Yes, I'm speaking about her because I understand everything is not her fault. Everything is not her fault. And we've actually been making great progress within the last month or so. That's why this hurts. That's why when they came and got me, I wasn't in the streets. I was sleeping, waiting to go to work.
Let me ask you this, Mr. Gay. What do you think that you deserve out of life? What do you deserve? What do you deserve out of life?
I deserve somebody that's gonna treat me the way I treat them.
Do you have that right now?
Sometimes I do.
Are you gonna go back to that? So let me ask you this. So you're saying some days you're worthy, other days you're not worthy. Or are you worthy every day?
I feel like I'm worthy every day because
if you had a car, you knew you had to go to work, and you had a car that some days it would start, some days it wouldn't start. Would you fix the car, get a different car, or will you continue getting fired from work because you don't show up on the day your car decides it's not going to work?
I'm gonna be to get a new car or fix it.
Okay, so fix your life. Stay away from this person if you don't want to keep going back to jail. If you want to go back to jail, stay around that person. That's the beauty of this country. You get to choose. You get to choose. Ain't nobody, it's not your mother, not your father, not her, it's you. Okay?
Yes, and another point, now I do remember what I was going to say at the end.
Okay.
The person that we're discussing, she was in the case, the women's side, she was on those cases.
Okay.
And she's the one that had the obstruction for justice.
Because they said that she tried to stop the police when they came to arrest you.
Yes, the point I'm trying to make is, if you really look at those situations, you can clearly see I'm not the problem.
Yes, you are. Yes, you are. I don't know why you believe that your poor decisions don't fall back on you.
Because
That's the problem. That's how you are the problem. You make poor decisions. You make poor decisions. If you decided that you were going to go to a party rather than pay your rent and you got kicked out of your apartment, is the apartment complex wrong or are you wrong?
I mean, you're wrong because you threw the party.
So no, you spent your money to go to the party.
Oh, you say go to the party. Oh.
Yes. If you keep making these poor decisions, you're going to keep coming back here and it's nobody's fault but yours. And I really hope you get that. Does that make sense to you?
I get it. I accept that it was because I shouldn't have stayed with her. I get that. I get that. I should have left, but I keep trying to voice to you that how do you leave when somebody does these things? When a woman, I know you're married.
I'll tell you how you leave. You pack a bag, you take 2 steps out the door, close the door, and you never look back. That's how you leave. Yes, sir. Go ahead.
I've done that and I got the police called on me.
Hey, sir, listen. Are you telling me she's kidnapping you? Is she holding you against your will? Is she doing something that prevents you from exercising free will? No, she's not. You're exercising free will. Things aren't working the way you want them to work. Now you're looking to blame somebody. You need to look in the mirror. I mean, I would carry a mirror in my pocket. Every time you think about going back to her, pull that mirror out and look at your face. Or even this is on YouTube, screenshot this and look at yourself on YouTube in an orange jumpsuit. And every time you think about, I just want to go back to her, pull that picture out and look at yourself on YouTube in an orange jumpsuit talking about, I just can't leave her. Am I getting through to you, sir? So, Mr. Gay, we all have to make decisions about our life. All of us, each one of us. When you become an adult, you can't turn around and blame somebody else. You have to look in the mirror. So if for whatever reason in your life, you believe that this is what you're worth, fine. I'm telling you, you're worth more than that. But only you can make that decision. Do we understand ourselves, sir? Do you have any more questions, Mr. Gay?
Like I stated earlier, I wasn't able to go to work, so I know their policy. I know they're probably about to fire me. So, and like I mentioned earlier, I don't have a mother. I don't have usually that person I could just call to bail me out. So, and I don't have my money on me. They didn't let me grab my money.
Uh-huh. Yeah. So let me ask you this. Do you think Miss Shannon is going to bond you out or try to lift a finger to help you get out of jail? Do you think Miss Shannon is going to get you a job back?
No, sir, I have to get out so I can get her out. I'm the one that makes the money. I'm not saying I'm going to be around her, but I'm saying I do care about her freedom. I don't need, she's 20 years old. I don't want her to mess up her life over not being able to control her emotions, because that's what's gotten us into this.
Sounds like she's messing up your life.
Yes.
But you keep going back.
I'm not trying to go back. I'm just letting you know I am literally a good person. I'm not what that looks like. All that, whatever those charges are, is not me.
Okay. Well, she told the police about that. So that's the person that you're going. Let me ask you this question. Let me try to explain it in a different way. If I told you that there's a rattlesnake in that basket and you just have to take the lid off, stick your hand in there, but it's going to bite you and you may die. And you stick your hand in there and the rattlesnake bites you, but you don't die. Then the next month I say, hey, it's a rattlesnake in that basket. Why don't you stick your hand in there? It's going to bite you, but you may not die or you may die. What I'm hearing from you is you're going to stick your hand right back in that basket and get bit. And you're going to keep doing it and keep doing it and keep doing it. And how I hear you experiencing this is I'm such a good person. I just cannot stop sticking my hand in the basket for that rattlesnake to bite me. So Judge, I mean, I know the rattlesnake keep biting me, but Judge, don't kill the rattlesnake, because the rattlesnake is actually a good rattlesnake.
She is a good person. It's just
no, she's not. No, she's not.
Yeah,
no,
she's not. Sometimes when she's angry.
Okay, well, sir. Now I'm wasting a bunch of people's time by having this conversation with you, but it just hurts my heart because I know I'm going to see you probably in another 3 or 4 months. Because the thing that you don't understand is that you're not the only person. And when I say I'm going to see you again, it's because I see people again. I know you're like, no, not going to be me. No, but hey, you know what, Judge? Yeah, you're right. She got mad at me. And I know I said I wasn't going to come back, and I didn't do anything. All I did was go back around her so that she can get me arrested again, but I didn't really do anything. Okay, fine. I'll see you. Let's say you want to put down July, August. When you want to come back and see me again?
I don't ever want to come back here, sir. I've done so much not to be.
So act accordingly.
Understand.
And I'm trying to pour energy into you, sir, so that you don't come back. People believe that people charged with crimes are violent, they're evil. No, just people make bad, poor decisions. So that's what you don't have to. I don't care. I don't care if you're evil. I don't care if you're good. I look at the charges. I do what I'm supposed to do. So when you say you're a good person, it really doesn't matter to me. You could be like the most evil person in the world, charged with the same offense, and you're going to get the same treatment. It's poor. It's decision making. Stop making poor decisions, please. Okay. Thank you, sir. Thank you, deputies, for indulging me.
I don't know my bond. I don't know my bond.
Okay. All right.
I don't want to keep
No. All right. $10,000 for the battery, $3,000 for the criminal trespass, damage to property, and $3,000 for the second criminal trespass. Just so you know, the warrant that was taken out on the other day was for criminal trespass, warrant number 2022 CW 51147. Warrants that were taken out in 2021 are for battery and criminal trespass. And as I stated before, the reason I set the bond at $10,000 on the battery, because you have two open warrants.
The other one happened after, and I was leaving, sir. That's what I'm saying. I was trying to leave.
Is this a trial? Did I appoint a lawyer to represent you? Do you have somebody you can say that you were leaving, and you right now have the opportunity to put 12 jurors in a box and go to trial and say, I was leaving? What is wrong? What is wrong with you, Mr. Gay?
Because I'm just not understanding how something like this could happen, even though I'm not even, I was never doing, I was trying to leave.
All right. So she called the police and told them that you did the stuff that was placed in a warrant, where the police officer went to a judge and said, I spoke to Miss Shannon. Miss Shannon said he did this. That based upon that, I'm seeking warrants for his arrest. That's what I think you're not getting. The person that you're all snuggly boo, I want to do, she is the reason, the only reason that you are in custody right now. She is the only reason that you are in custody right now. So go back to that. Because what you're telling me is that she's a liar. She lies and gets you arrested. But oh, I love her so much. She can, I mean, when she's not lying, I want to be around her. Great. That's why you're going to be back here again. Because you've already said she doesn't tell the truth all the time. She lies at times. Guess what? When she decides she's going to lie, she's going to call the police. There's going to be another warrant for your arrest, and you're going to go back to jail. And you're going to get out, and you're going to go back to her, and she's going to do it again, and do it again, and do it again, until one day, either you're going to be in jail for 5 years, and you're going to have time to separate yourself from that, or someone is going to tell you, or you're going to learn on your own. This is not a good look. This is not a good relationship. So, sir, you're doing it to yourself. I have no problem in following the law, but you are wasting people's time. Is there any other questions that I can answer that are of value?
Yes, sir. Is there, because like I said, I'm the one that makes the money, and I don't have that much. Is there any way we can work on that, the price of the bond, so I can get out?
No. Next question.
I forgot what. Thank you.
So, Mr. Gay, what I'm sensing from you is that you are somehow trying to talk me off of something that, no, stop. You're trying to talk me off of something that I told you I'm not going to change. I don't understand why you're standing here, but it's my job to answer questions. So keep asking and I'll keep answering.
You never answered the question about what should I have done in the situation when I actually did what you said.
Didn't answer that question.
Yeah, he told
I did. I've answered it, I think, about 3 or 4 times.
No, when you told me that you to pack your bag and leave, and I told you I did that. What else am I supposed to do?
You said that she does this once a month. You said she does this once a month. So
That's,
you have.
that's if I had to. That's if I had to put into statistic. Yes.
Deputies, am I being unclear to Mr. Gay, or is it he just don't want
Clear, sir. All right, Mr. Gay, do you have any questions that do with bond or court date? Yes or no? If not, let's go.
What was the court date? Since I'm being held there.
All right. We're going to do this again. Mr. Gay, and I want you to listen to everything I say. You're charged in warrant number 2021 CW 56317 with committing the offense of battery. The bond is going to be set at $10,000. This warrant was taken out on December 30th of 2021, with Ms. Shannon being the complaining witness. You're also charged in warrant number 2021 CW 56318. Bond is going to be set at $3,000. That charge is criminal trespass, damage to property. That bond was also taken out on December 30th, 2021, with Ms. Shannon being the complaining witness. So you're charged in warrant number 2022 CW 51147 with committing the offense of criminal trespass. That warrant was taken out on March 17th of 2022 at 12:07 a.m. So a judge had to get waken up to do this warrant, with Ms. Shannon as being the complaining witness. Bond's going to be set at $3,000. These are misdemeanor offenses. You're going to have a preliminary hearing date set for April 26th, at 8:30 in the morning, courtroom 201. That date will get waived when you're bonding out, and you'll get a new court date in the mail. I've appointed a lawyer to represent you. Is there anything else that you don't understand, Mr. Gay?
How did I get criminal trespassing?
Because which one?
The first
For
one
December or for March?
for December.
Okay.
I can see how it happened for March.
Bob, stop talking. Stop talking. Because when you start talking, you start forgetting things. You asked a question, I'm about to answer it. So the allegation is on December 30th, 2021, at an address on Riverdale Road, you did commit the offense of criminal trespass, damage to property. On that above date and time, you allegedly committed an act of criminal trespass, and that you allegedly intentionally damaged an iPhone 10 and a 50-inch Samsung flat screen television, the property of Miss Shannon, without her consent, by throwing the phone, causing the screen and the back glass to shatter. Said offender damaged the television by dropping it to the ground. Said damage being less than $500. That's the allegation against you. I've appointed a lawyer to represent you. You now know the charge. Speak to the lawyer about it so the lawyer can defend you.
I just need the total, that's it.
16,000.
16?
Yes. April 20, that's 14. You have any questions for the judge?
Yes, sir. I'm done.
All right.
Can you take us off YouTube and before you let